A Goodwill employee facing felony theft charges for what he says he thought was a good deed. 19-year-old Andrew Anderson from Florida giving discounts to low-income customers. The teen says he just wanted to help out people who he thought needed a hand. Officials at Goodwill releasing a statement saying in incidents like this, we always prosecute. And the reason why is when people steal from Goodwill, they're not stealing from the company, they're stealing from the mission of our organization. That teen now facing up to 5 years in prison. An appeals court ordering a new trial for a Florida woman who was sentenced to 20 years in prison after firing a warning shot into a wall during a fight with her husband. Marissa Alexander tried to use Florida's controversial Stand Your Ground law, arguing she fired the shot to scare off her husband, feeling that he was threatening her. But the judge initially ruled against her. No one was hurt. Prosecutors do claim, though, that she gave him a black eye. He had previously been convicted of attacking her. And at the time of the shooting, she apparently had an active restraining order against him. Let's talk about it. Doug Burns is a former federal prosecutor. Dan Shore is a former prosecutor and associate managing editor at Kroll. All right, Dan, I'll start with you. It seems there was some trouble below about the explanation of just exactly how that Stand Your Ground law would work. And this woman ended up with 20 years in prison. Now she's got a second chance.
Right. There were a few problems on the trial level. First of all, they defined the burden of proof for self-defense wrong. Once the defendant raises self-defense, the prosecution has to disprove it beyond a reasonable doubt. In Florida, the judge incorrectly said the defense had to prove self-defense beyond a reasonable doubt. So she deserves a new trial. Now the issue is going to be, can the prosecution still prove that she's guilty beyond a reasonable doubt? She's saying that she was standing her ground. The prosecution is saying she had an avenue of escape and then came back. And that's the factual dispute that we'll see play out here.
Yeah, and Doug, apparently that there is in Florida a mandatory minimum because she used a gun, and that's how she ended up with 20 years. But as we mentioned, there was a restraining order against him. He'd been convicted previously, my understanding is, of domestic violence in the past or some type of domestic assault. Right. She's 5'2". He's a big guy, weighs 245 pounds. This got a lot of public attention and a lot of folks who thought, if Stand Your Ground means anything, this is where it should have applied.
Well, yes and no. I mean, what happened here, though, there's a little factual gloss that really deserves some analysis, and that is, and it's funny because I tried a case very, very similar to this about 5 years ago. What happened was, Shannon, she was in the argument with him, but then left, went outside, was in the garage apparently, got the weapon, and then went back in. And that makes for a big, big difference factually. I agree with you 100%, Shannon, when you're saying stand your ground means stand your ground. But again, here, the argument from the prosecutors is going to be, wait a minute, once you left the house, all bets are off. You never should have come back in. And so the fact of the matter is, on the practical level, I also want to note quickly that they offered her a 3-year plea. As opposed to the 20, which was pretty fair on their part, given the facts as I just explained them. So now the key question is, will they offer that again? Because I'll tell you what, if they do, she'll take it so fast your head will be spinning.
Yeah, once you've done time in prison,
yeah.
Not speaking from experience, I'm guessing that you don't want to go back when you've experienced it and you know
Exactly.
what it's like to be away from your family and lose your freedom. Dan, in this case, it says the jury took only 12 minutes to find her guilty of the 3 counts of aggravated assault with a deadly weapon that wound up sending her to jail. A judge obviously is in a different role than a jury, and they're looking at something different here. Do you think her odds are good?
Well, if you look at how fast the jury came back, that certainly doesn't bode well for the defense. However, they will be instructing the jury on self-defense in a different manner, in the correct manner now. It was wrongly done in the first trial, and that's why it was reversed. So she might have a better chance there. Ultimately, this will come down to factually, will the jury believe that she actually was standing her ground, or will they think that she left, had a way of really leaving the house, but came back anyway with a gun and then fired it?
All right, Doug, let's break this down a little bit. The defendant's burden in this case, this would be the woman who fired the gun, is to raise a reasonable doubt concerning self-defense. But apparently, in the ruling below, the judge had told the jury she was required to prove self-defense beyond a reasonable doubt. So break that down for us in layman's terms, what the difference is and how big of a difference it is.
There's quite a big difference, actually, and the word reasonable thrown in there makes it confused. Basically, in any type of what we call legal defense, entrapment, or in this case, self-defense, there's sort of a minimal threshold where you have to put that issue into play before the jury enough to require the judge to give a jury instruction. And it's generally not that high a burden. So the point is, the lawyer, and I've been in this situation many, many times, Your Honor, we've introduced enough evidence about self-defense, and we'd like you to instruct the jury. But then, as my colleague Dan correctly explained, the correct instruction is, ladies and gentlemen, you know that self-defense was raised, and now that it's in the case, I instruct you as a matter of law that the prosecution must prove beyond a reasonable doubt, as Dan said, that it wasn't self-defense. And we discussed this over and over in the Zimmerman case, obviously.
All right, I'm having a flashback to law school. I feel like I just had a very informative lecture. Dan and Doug, thank you both very much.
Thank you.
My pleasure.
We'll watch for that new trial.